Welcome to Think Big Virtual Forum, a look at how impact assessment can help with a cleaner, greener economic recovery from COVID-19. I'm Peter Henderson from Reuters News, and I'm your moderator. We're in the fourth of 6 sessions in this series, sponsored by the International Association for Impact Assessment and the Earth Law Center. Today we're going to talk about institutional change and how it can help with biodiversity restoration and climate action. Our first speaker is going to be Ted Bowling. He's a partner at Perkins Coie. He's a former associate director of the U.S. Council on Environmental Quality, where he defended the National Environmental Policy Act. He's going to talk to us about the evolution of the environmental impact assessment in the United States, where the economy is getting greener and cleaner.
Hello, I'm Ted Bowling. I am a partner at the law firm of Perkins Coie in Washington, D.C., their Washington, D.C. office, that is. For immediately prior to joining the law firm, I was an official at the Council on Environmental Quality. I served at the Council on Environmental Quality for about 15 years of my 30-year federal career, first as Deputy General Counsel, then General Counsel. I served as a Senior Counsel, and then later as Associate Director for the National Environmental Policy Act. Over the course of my career, I was also a Deputy Solicitor at the U.S. Department of the Interior and a trial attorney at the U.S. Department of Justice. But what I'm going to talk with you today is the Council on Environmental Quality, the office that was created by the National Environmental Policy Act, the governing environmental impact assessment authority of the United States. And NEPA, as it's commonly known, created both the environmental impact assessment requirement and also in Title II of NEPA, the Council on Environmental Quality. It's most famously known as this. It's a very broad, ambitious statement of national environmental policy. Its establishment of the procedural requirements of environmental impact assessment that is binding on all agencies of the federal government. And then lesser, but certainly the originating authority for the Council on Environmental Quality, which was created largely to ensure the effective implementation of that national environmental policy. So NEPA in the federal government serves to integrate environmental values into federal decision-making, requires that federal agencies consider the environmental consequences of proposals for federal agency action, particularly those that may significantly affect the quality of the human environment. It also provides that information to the public. So it is an exercise in environmental democracy, allowing the public to see what federal agencies are planning and to participate in that decision making. Basic elements are that NEPA applies to proposals for agency action, most definitely to those that are major and significantly affect the quality of the human environment. There's pending an issue of statutory construction reopened by the CEQ rulemaking in 2020, updating those rules as to what the scope of that statute is. But certainly the statute applies to all of the large infrastructure projects that have a significant federal nexus, a federal decision-making component to it. That's not to say that there aren't large infrastructure projects that proceed outside this federal sphere, but generally the major infrastructure projects are subject to the National Environmental Policy Act. Typically, in various infrastructure sectors, you have various streamlining efforts by Congress to amplify the role of NEPA in sort of timely delivery of environmental impact assessment for decision-making processes. The NEPA process is governed by the Council on Environmental Quality's regulations. As one of their major functions, but another function that they serve is the adaptation of those regulations to the various federal agencies. So the application of the environmental impact assessment process to those specific agencies through their own NEPA procedures, which are subject to review and approval by the Council on Environmental Quality. There are literally thousands of cases interpreting the National Environmental Policy Act. Typically, the federal government makes over 100,000 decisions per year with some degree of NEPA analysis. The vast majority of that is categorically excluded actions, which are actions that in individual agency NEPA procedures have been identified as not significant unless there are extraordinary circumstances. Roughly 10,000 environmental assessments are done per year, and we seem to be averaging at about 250 environmental impact statements being in draft for final form per year, right? Judging by the rate at which they are publicly described. The NEPA charges the Council on Environmental Quality to promote the means of preventing or eliminating damage to the environment. You look at the basic purpose section, it's talking about eliminating damage to the biosphere, a very broad statement mandate for CEQ. It's also one of the first statutes to talk about ecological systems and natural resources and enhancing the public's understanding of that. But ultimately, it's a matter of productive and enjoyable harmony. Man and nature in productive harmony is the phrase typically used. But the statute is action forcing. It is enforceable by federal courts. It is law, not as soft law, but actually hard law. Projects can actually be stopped by the courts if there's not adequate NEPA compliance. So federal agencies pay close attention to their NEPA requirements, particularly the action forcing provision of a detailed statement, the environmental impact statement, on the impacts of their proposed action, adverse environmental effects that including those that can't be avoided, and alternatives to the proposed action. And those are alternative means of avoiding, minimizing, or compensating, otherwise ameliorating those environmental harms. As I said, Congress has elaborated on NEPA, provided for various sort of streamlining mechanisms. Streamlining has a negative connotation of lined streams, as in streams lined with concrete. But generally, these statutes exist primarily for ensuring that there are efficient environmental reviews, that the environmental review process for, say, transportation projects under Title 23 of the U.S. Code, Section 139, designed to make sure that highway projects, transit projects, rail projects move forward in a predictable fashion and in a coordinated fashion. Likewise, Water Resources Development Act provided for an efficient process with support. I'm going to talk a little bit about Title 41 of the FAST Act, the Fixing America's Surface Transportation Act, which was actually much broader than surface transportation. It applies to renewable energy as well as conventional energy, all manner of infrastructure projects. It created a federal permitting and improvement steering council on which the Council on Environmental Quality sits as a member and actually has a very strong role to play. CEQ is identified in FAST Act as the final arbiter with regard to methodological disputes, with regard to disputes between agencies on their timelines. Those go to another agency within the Executive Office of the President, the Office of Management and Budget. But the FAST Act is available to project proponents, infrastructure project proponents, if their project is subject to NEPA and is a large project. The marker in the statute is $200 million in investment, although that's not absolute. If it's of a sufficient size and complexity, the permitting council will accept it as a FAST project. And there, as I said, there are other provisions in the Surface Transportation Law and the Water Resources Development Act that have their own processes, so the permitting council process doesn't apply to that. But what it does provide is what we call the dashboard. It's an active tracking of the project and all of its milestones, all of its various authorizations associated with the NEPA process, because the NEPA process is not just environmental impact assessment for its own sake, but it's for informing various federal agency decisions, including decisions under many different statutes, Endangered Species Act, National Historic Preservation Act. It's a means of coordinating all that. And so the statutory means of coordinating by the FAST Act is performance schedules and the creation of a project plan, a coordinated project plan, and then the use of cooperating agencies and leadership that's required by the FAST Act. Every department now has a chief environmental review and permitting officer, who's someone who's just there to make sure that things happen when they're supposed to happen, that there are issue resolution, that and then if when the project is completed, gets to a record of decision, if there's litigation, there are some provisions with regard to tightening the timelines. There's a 2-year statute of limitations, for example, for litigation. But ultimately, this is designed to ensure that we have a clear start to the environmental review process. It's not waiting for a notice of intent to be issued by the federal agency, but that the project sponsor can initiate this high-level attention for a project and get a decision as to whether their project qualifies for that level of dashboard treatment and permitting council review. It reaffirms that the lead federal agency sets the schedule and limits the ways in which federal agencies can modify the schedule, and it indeed provides for congressional oversight for that. As I said, these projects are all on the project dashboard, the URL for which is in the previous slide, and it's included emphasis in there with regard to the judiciary to give due consideration to environmental impacts and really job impacts, if you will, on and then also has provisions that require the litigants in those lawsuits have actually participated in the NEPA process, such that you cannot raise a claim for the first time in federal courts. You have to have actually identified a deficiency in the environmental analysis during the public comment periods for the environmental analysis, and that and then you are then limited to what you raise to the federal agencies by what you can bring to federal court review. So, as I said, the Council on Environmental Quality has a very strong role to play in all this, because their regulations are really foundational to the entire exercise of infrastructure development in the federal government. Those regulations had been untouched except for one amendment in 1986, since they were promulgated in 1978. So a very good run for federal agency regulations, but and certainly they were embraced by the United States Supreme Court. First in the Andrus case, later on reaffirmed by multiple Supreme Court cases. The Robertson v. Methow Valley Citizens Council case is one of the leading examples of that, holding that the CEQ's interpretation of NEPA was entitled to substantial deference, not just in the 1978 regulations, but then also in their amendment in 1986. So as I said, the regulations were amended comprehensively revised for the first time last year. The Biden administration is in the midst of revisiting those amendments, has actually proposed some small tailored changes for public comment in November of 2021. and has mapped out an agenda of doing a broader phase 2 update to those regulations. So it's a bit of a moving target, and it comes at a time when the the federal agencies are trying to also move forward on a clean energy agenda, and they have something of a shifting baseline for environmental impact assessment. First of all, the 2020 regulations changed some of the discussion of the relationship between the regulations and the courts, particularly with regard to exhaustion of your administrative remedies using the NEPA process, and then also created new provisions with regard to categorical exclusions. It expanded the scoping provisions, but then also added timelines, a presumptive 2-year timeline for environmental impact statements, unless a longer time is allowed by a senior agency official, and 1 year for environmental assessments. And then changed some of the provisions with regard to the environmental impact statement, including a broadening of the purpose and need provision to include the goals of the applicant. Now, CEQ has proposed to take that back to the 1978 language, but also, broadening the discussion of the affected environment to include reasonably foreseeable changes in the affected environment, which would include climate change, I would say. And then also amending the provisions for public comments and basically encouraging the public to provide as much substance as possible in the comments, although general comments are still regarded generally. It expanded the provisions for interagency referrals to the Council on Environmental Quality to make clear that agencies that disagree with one agency's assessment that they can authorize a project on the basis of an environmental assessment and a finding of a significant impact, that they can bring that to CEQ for an interagency adjudication. And then clarifying that the importance of the consideration of alternatives and information and analysis and objections to the final environmental impact statement, making that part of the record of decision, emphasizing the coordination between the federal government, states, tribes, and local cooperation. Indeed, the addition of tribes, which are domestic, sovereigns in their own right within the United States. That was a theme running throughout the update to the CEQ regulations. And then CEQ also in 2020 required agencies to adopt new NEPA procedures by September of this year. The Biden administration expanded that to extended that by 2 years. But we have this evolving or now somewhat dynamic environmental impact assessment process. At the same time that the federal government has this goal of dramatically expanding our renewable energy capacity, including offshore wind development, a goal of 30 gigawatts of offshore wind development by 2030. And what we have here is a map of all the lease sales, or rather the leasing areas that are pending or currently under consideration. In the northeast corner of the map, you have the Vineyard Wind project, which has been authorized this year. Is one of the first very large-scale offshore wind projects to be authorized with its transmission line leading to Cape Cod, Massachusetts. But then going on down the coast, you have a series of lease sales, you have proposals for construction and operation plans, a dramatic expansion underway. And currently, the only wind power in the federal outer continental shelf currently being generated is by the 5 turbines at Block Island, south of the state of Rhode Island, and then 2 turbines to the east of Virginia. The Coastal Virginia Offshore Wind Project, however, would expand that dramatically, as would projects from North Carolina all the way up to Massachusetts. And now we're even considering the Gulf of Maine for floating platforms there. So it's an intense time within the federal government for all of these agencies listed here. They all have various authorities that they bring to bear on the decisions to authorize a construction and operation plan for the development of offshore wind, to authorize the transmission lines, and then also for the Federal Energy Regulatory Commission, which is not on here, but they're and the state agencies that are and independent system operators, the regional transmission organizations, on how to integrate that. And the NEPA process is going to be central to all that. The NEPA process has been central as a means of figuring out how do we do this consistent with the biodiversity goals of the United States, the fisheries management goals of the United States, and involve underserved communities, those communities that have been marginalized, that what we typically call an environmental justice case, where polluting industries have been located there in their neighborhoods, and in many cases, some of these power lines are going to tie into generating capacity that formerly was a large power plant there and in a coastal city, and with its own history of environmental contamination. And so how do we address those issues? It's a fascinating time to be working in this area, and I'm so happy to have had the opportunity with the International Association of Impact Assessment to offer this little summary of where things stand, and I look forward to seeing you in Vancouver in 2022. Thank you.
Thanks, Ted. Next, we'll hear from Herman Green. He's president of the Center for Ecozoic Studies, a study of ecological civilization. It's a change from our original plan for a case study on rights of nature in Colombia, but we're going to hear from Herman about Earth law and its connections to impact assessment.
Hello, I'm Herman Green, and I'm going to give a talk on impact assessment in the Anthropocene. First, let me introduce myself. Grant Wilson, the Executive Director of the Earth Law Center, after he heard that I ran my 23rd marathon at age 76, said that I should always introduce myself that way. Well, I don't know if I'll do it in the future, but I'll do it today. I'm also a retired business lawyer, the founder of the Center for Ecozoic Studies, a research and education center for an ecological age, and I'm a member of the board of directors of the Earth Law Center with a focus on legal theory and educating Earth advocates. The aim of this talk is to think big about impact assessment in view of COVID-19 recovery, biodiversity restoration, and climate action, all from an Earth law perspective. When we think about impact assessments, for those of you who are in the practice of that, it begins with the law. That's why you do the assessment, because that's what the law says is needed. And that's a problem, because the law is a bunch of little boxes, and practicing law is about putting things in those little boxes. So for example, something says there's a 31-day notice period. You file on day 28. You're in one box, you're in the good box. You file on day 32 and you're in another box, you're in a bad box. In counseling clients and in developing impact assessments, we often look to the law, those little boxes, and what is needed to fill those boxes before we look to the problem itself. We parse words in the law to make what we have fit to make those objectives and obligations of ourselves fit those little boxes. I want to talk about the Holocene. That's the current geological epoch that began about the time of agriculture, 11 or 12,000 years ago. The Industrial Revolution, which is an extraordinary period of human history, began about 250 years ago. And the Anthropocene, which is our current period. The law, as we know it, that is codes and judges and attorneys and all the structures of law, began around 2,000 years ago. The Code of Hammurabi was in 1750 BC. US law was derived from common law, which goes back into the history of England about 800 years ago. On the civil side, from common law and American law, property, human rights, and contract are at the base of law. Since the period of the Civil War, US law has moved increasingly to facilitate commerce and industrial development. Progress, growth, which is meant to bring about shared prosperity and has to some extent, democracy, freedom, and domestic tranquility have held us together. With glaring exceptions, we have lived the American dream. We were anthropocentric and we were Eurocentric. We were and are the global North. There's a nagging issue in this dream, the environmental cost of development. People are now calling the period after World War II the period of the Great Acceleration, because while there was growth throughout the Industrial Revolution period, growth really accelerated after World War II. And along with that, more and more environmental effects. So the need to deal with those industrial accidents and other effects gave rise to modern environmental law in the 1960s and 70s. And the purpose of the environmental law was to make industrial development safe for humans. So you can see there's several key things there. Keeping industrial developments going and making it safe for humans. To a lesser extent, those environmental laws have involved conservation of resources and preserving ecosystems and biodiversity. The first of the major laws that was adopted was the National Environmental Policy Act in 1969. There they gave a broad understanding to environment to include cultural, historical, and social welfare concerns, as well as concerns for the natural world. Many benefits have accrued from environmental regulation, but on a global basis, the quality of the global environment has declined. So we, meaning us of the modern period, invented sustainable development and green growth. Sustainable development was always an oxymoron because development has meant a particular kind of growth. Industrial development based on fossil fuels and extravagant extraction and use of other low entropy materials. 1999 was a watershed year of awareness, when Paul Crutzen and Eugene Stormer, in an article published, well, I see it was published in 2000, gave the name to our current period, the period of the Anthropocene. because the human impact on the Earth had grown so large that we could be said to be the major driver of climate and of the environment. Another word was given to the condition we were in a little bit earlier. It's still little understood and little accepted. That word is overshoot. As you know, when a species grows too large for the supporting ecosystem, it goes into overshoot and there's a dieback. We've been able to sustain overshoot by the massive drawdown of the fossil mineral resources. We continue to live in what William Catton, who wrote the book Overshoot, called the age of exuberant expectations of a perpetually expansive life. And this is all sustained by the drawing down of finite reservoir of the remains of ancient organisms. So we invented clean tech, renewable energy, net zero, sustainable development goals, et cetera, et cetera, et cetera. Bruce Jennings in Ecological Governments of 2016 raised the following critical question. The dilemma for leaders today is that, on the one hand, social order and stability in virtually every nation rest on economic activity based on the intensive procurement and use of energy-rich fossil fuels. This has made possible most of modern technology and industrial civilization. And on the other hand, the procurement and use of these fuels and the industrial systems they support poses an imminent threat to civilization. Modernity's storyline is that natural limits can always be overcome by technological innovation or substitution of materials or sources. Jennings points out, however, that earlier natural limits were not overcome. Rather, humans found natural pathways that would handle the burden of human extraction and production of waste and pollutions. And he raises this is the question: are humans now facing absolute natural limits, sometimes called planetary boundaries, that make the continuation of the consumptive social contract not only unwise in the near term, but also impossible in the medium and long term? I would add these questions. Is it possible to maintain the extreme imbalances of power and well-being between the global north and the global south, between humans and other species, between present and future generations, between the globalized economy and Earth's life support systems, between Eurocentric and other ways of living and being? What if further development, including the rapid deployment of clean tech and renewable energy, only leads us further into overshoot and the extension of these imbalances of power? Then, what is an environmental impact assessment? I'll only answer the above question from the standpoint of what we are attempting to do with Earth Law. Environmental impact assessment is the exercise of 4 of the most important dimensions of being human. The dimension of our ability to analyze and assess things, our ability to reflect on what we see and know, critical reflection, our ability to think about the future, and our ability to imagine or envision alternative futures. So even if the answer to those questions is that we've reached absolute limits and we can't sustain those imbalances, the need for the exercise of these 4 dimensions is more important than ever. And the need for environmental impact assessment is more important than ever. But just as with law, we have to get environmental impact assessment out of the box. So we say for Earth law, first of all, we say it's based on a different ontology. That environmental law is based on ontology of separation between humans and nature, and that Earth law is based on ontology of interrelatedness and entanglement. We say the Earth law is the emerging body of law for protecting, restoring, and stabilizing the functional interdependencies of Earth's life and life support systems at the local, bioregional, national, and global levels. Earth law may be expressed in constitutional, statutory, common law, and customary law, as well as in treaties and other agreements, both public and private. There's a lot that's in there, but I want to point out that we're also talking about customary law, things that would not be in little boxes. Earth law focuses on the role of law in the survival, health, and well-being of humans and the larger community of life and life systems in the context of the Anthropocene. That discussed below goes with the paper this is taken out of. Its purpose is to provide the legal framework needed so that humans live within planetary boundaries. Well, now, what would it mean to undertake an environmental assessment that takes planetary boundaries into account? Prospectively care for ecosystems. It's not what's the immediate damage, but how do these ecosystems stay healthy now and in the future? Preserve biodiversity. This is a huge issue. As you know, and I can quote you statistics, we're not doing very well at that at all. And there's a huge cost to that. Restore damaged ecosystems and loss of biodiversity. So what kind of benefits need to come with projects that allow that to happen? Protect human environmental rights, and justly share the burdens of mitigating and adapting to climate change and other environmental stresses, because it's going to be difficult. A distinctive feature of Earth law is that nature is taken into consideration in its own right, and the benefits, protections, and remedies afforded by law are extended to nature in its own right. In a sense, nature becomes a third party in every legal process. So I would say in projects to build things, that there would be the humans involved on different sides of an issue, and there'd also be nature, and they would be given equal weight in the consideration. Finally, Earth law concerns ecocentric governance. So when we're thinking about Earth law, we're not thinking about the legal system as it exists today. I don't think the legal system as it exists today can adequately address the needs of the future. For example, property divides the Earth into these little, again, boxes. But that's not at all the way the Earth functions. The legal system is adversarial, but that's not the way that we're going to make progress in the future. Now, how we get to that? Well, we get to it by saying that, first of all, we need to get to it, that we need to move beyond that to our shared humanity, our shared place in the planet. It begins with the creation of a new social contract. The existing social contract is between humans, but the new one is among humans and other living beings and life systems. And it involves every aspect of human societies that involves the setting of norms and values and the enforcement thereof. So Earth law, environmental assessment has to be supported by the larger community. Imagine, suppose we thought of environmental impact assessments as Earth impact assessments. Just as this forum has been co-sponsored by the International Association of Impact Assessment and the Earth Law Center, we of the Earth Law Center invite IAIA and those of you who are participants in this forum can join us in stepping out of the box of real-world anthropocentric thinking to the real world of ecocentric thinking. This latter world is not established. It is emerging. It will be realized in practice. Thank you.
Thank you, Herman. That winds up our session for today. The next session is on Tuesday, November 16th. We hope to see you there. That'll be about using impact assessment to make wiser choices for the planet. In the meantime, check out our website, thinkbig.iaia.org. You can leave your thoughts, ask some questions, and join the community. See you next time.